6:22 a.m., February 14th, 2026. Houston, Texas. 14 federal agents moved through Terminal E of George Bush Intercontinental Airport in 2 staggered columns. They were not running. They did not need to. The man they were looking for had already checked in. His boarding pass scanned at 6:09 a.m. His carry-on cleared security at 6:14. He was sitting at gate E12, a coffee in his hand, watching the departure board. The flight to Dubai was scheduled to leave at 7:05 a.m. He would not be on it. Estimated payments received for classified U.S. Navy Transit Intelligence, $1.4 million, transferred across 11 years. Routed through a Cyprus-registered shell company to a personal account in Houston. The operation that moved those funds started in 2013. The warrant that ended it was served on a Saturday morning in February 2026. 11 years, 3 months, and 14 days after the first classified document left a secured server room in Norfolk, Virginia. The man with the coffee cup at gate E12 had no idea what was coming. That was the point. His name, for purposes of this account, is referred to in federal court documents as the defendant, a defense logistics consultant, clearance level, top secret, with sensitive compartmented information access. 12 years of contracts with naval commands across the eastern seaboard. A man who had, by every visible metric, built a career on access and discretion. He had been discreet about the wrong things. The agents moved through the concourse. Overhead, flight information updated in yellow digital blocks. Gate E12, Dubai. Boarding at 6:40 a.m. They had 18 minutes. The lead agent from the FBI Joint Counterintelligence Task Force had reviewed the arrest protocol 3 times that morning. The subject was not considered armed. He had no prior criminal record. His risk profile was classified as moderate. What he did have was a one-way ticket on Emirates Flight 235 and a carry-on bag containing a personal laptop, 2 mobile phones, and a Cayman Islands bank routing slip that nobody at the airport yet knew about. The agents split at the gate entrance. 4 took positions at the secondary corridor. 6 moved directly toward row 7 of the seating area. 2 others coordinated with airport security near the jetway. The subject looked up from his phone. And in that moment, in the 6 seconds between recognition and the production of credentials, 11 years of classified damage, intercepted naval communications, and 1 administratively closed federal file converged on a single man sitting with a paper coffee cup in Terminal E. He did not run. He put the coffee down. To understand what happened at Gate E12 on February 14th, 2026, you have to go back to the fall of 2014, to a different kind of quiet. The Strait of Hormuz is 21 miles wide at its narrowest point. Roughly 30% of all seaborne oil transits through it. For the US Navy, it is one of the most operationally sensitive maritime choke points in the world. Ships don't pass through casually. They pass through on schedule, at depth, with coordinated timing, with routes that are classified, reviewed, and updated at regular intervals to minimize predictability. In the fall of 2014, that predictability started breaking down. NSA signals analysts monitoring Iranian military communications flagged something unusual in October of that year. Iranian naval command traffic contained references to U.S. vessel movements that were too accurate to be coincidental. Not vague directional intelligence. Specific timing windows, transit corridors, vessel classes. The kind of information that does not come from satellite observation or open source tracking. The kind that comes from inside. The National Security Agency forwarded the flag to the Naval Criminal Investigative Service on October 29, 2014. NCIS opened a mole hunt the following week. The investigation had a name, a case number, and a team of 9 investigators drawn from NCIS and a detached element of the FBI's counterintelligence division. It also had a problem. The pool of personnel with access to US. Navy transit schedules for Hormuz operations in that period was not small. It covered active duty naval officers, civilian GS-level analysts, and a tier of defense contractors embedded in logistics and planning functions. When investigators mapped the access logs from the relevant server architecture, they identified 412 individuals with some level of authorized access during the window in question. 412 suspects. 3 confirmed leak events. 11 months of investigation. What this case illustrates isn't the complexity of the breach. It's how completely a single well-placed contractor can exploit institutional trust. The military contractor boundary is deliberately porous. It has to be. The problem is that the oversight systems built around that porosity were designed for a different threat environment. By the spring of 2015, investigators had worked down to a shortlist of 18 individuals whose access patterns, financial records, and behavioral indicators placed them in an elevated risk category. They cleared 14 of those 18 through a combination of polygraph examination, financial review, and surveillance. The remaining 4 were subjected to extended scrutiny. None of them broke. None of them were the source. The investigation had been looking in the right building. It had been looking at the wrong floor. The defense logistics consultant did not appear in the early shortlists because his access to transit schedule files, while technically within his contractual scope, was categorized as incidental rather than operational. He was not a naval intelligence officer. He was not an analyst. He was a contractor with a support function, logistics coordination for material transfers, and his SCI access had been granted as a blanket administrative accommodation, the kind of low-visibility clearance expansion that happens routinely and gets reviewed infrequently. He had accessed 34 transit schedule files in a 72-hour window before each of the 3 confirmed leak events. That number, 34 files, 72 hours, 3 times, would not surface for 11 years. The investigation stalled in the winter of 2015. The leak had stopped. Whether the source had gone quiet deliberately or had simply completed whatever arrangement was driving, the disclosures was unclear. The evidence trail, which had never been strong, dissolved into a thicket of contractor shell accounts, administrative access logs that had not been retained past their standard deletion window, and financial records too dispersed to reconstruct without a direct subpoena target. In January 2016, the case file was administratively closed. It transferred to a low-priority archival unit within NCIS's Counterintelligence Division. The case number stayed open in a technical sense. Federal counterintelligence files are never formally closed, but no active resources were assigned to it. Nobody expected it to move again. I spent a considerable amount of time going through the procedural sequence of that closure, and one detail kept coming back. The archival transfer documentation contains a line in the case summary that reads, "Access anomaly patterns insufficient for prosecution threshold. No confirmed link to financial benefit." What it doesn't say, and what only became clear a decade later, is that the financial benefit existed in full. It had simply been routed through a layer of financial architecture that the 2015 investigation was not equipped to penetrate. In the years after the original NCIS investigation closed, the defendant built something. By 2019, he had moved from embedded contractor work into private maritime security consulting. His firm, registered in Texas, provided risk assessment and logistics intelligence services to commercial shipping companies operating in the Persian Gulf. It was a logical extension of his prior work. His background, his contacts, his institutional knowledge of naval operations in the region made him credible and marketable to clients who needed to understand the security environment their vessels were operating in. The firm grew. By 2022, it held active contracts with shipping companies registered in the UAE, with a private logistics operator in Oman, and with at least one entity, the details of which remain sealed in court filings, whose beneficial ownership structure had connections to entities operating across multiple jurisdictions in the Gulf region. The defendant travelled frequently: Dubai, Abu Dhabi, Muscat. He kept a residence in Houston and a service address in Dubai. He was, by the visible metrics of his industry, successful. The Cyprus registered LLC that had been receiving payments since 2013 remained active throughout this period. It was not dormant. It continued to process wire transfers at irregular intervals into the defendant's personal accounts. Between 2013 and 2016, the active period of the original NCIS investigations timeline, those transfers totaled $1.4 million. After 2016, the transfers stopped. The LLC stayed registered. No activity. No dissolution. Just an entity sitting in a Cypriot corporate registry, its beneficial ownership obscured behind a layer of nominee directors and a registered agent who serviced hundreds of similar vehicles. It waited. Put yourself in the position of a counterintelligence analyst in November 2025, 11 years out from the original investigation, with no active case and a 72-hour access pattern buried in archival logs that have been sitting in cold storage since the Obama administration. You are not looking for this. You are looking for something else entirely. That is precisely how it surfaced. In the fall of 2025, UHA's naval operations in the Strait of Hormuz entered a period of elevated intensity. Iranian forces had conducted a series of tanker interdictions in September and October, actions that prompted an increased U.S. naval presence and a corresponding review of operational security protocols across all contractor access systems with historical Hormuz relevance. The review was, in its initial scope, administrative. A counterintelligence compliance audit, the kind that gets run periodically when the operational environment shifts. A small team within the FBI's National Security Division was assigned to review contractor access records across a defined historical window, 2012 to 2017, for any patterns that had not been adequately resolved at the time. It was not a targeted investigation. There was no specific suspect. It was a bureaucratic sweep of old data, the kind of exercise that produces nothing 98% of the time. On November 4th, 2025, an analyst working through a batch of archived access logs from a Norfolk-based server cluster flagged a pattern: 34 files, 72 hours, 3 iterations. The analyst pulled the contractor record attached to the access signature: Defense Logistics. SCI access granted 2011. Contract terminated 2017 following the natural expiration of his primary naval client agreement. No adverse action, no flag, clean termination. Current occupation, private maritime security consulting. Houston, Texas. Active contracts in the UAE. The analyst submitted the flag to her supervisor at 4:47 p.m. on November 4th. The supervisor escalated it to the FBI Joint Counterintelligence Task Force the following morning. By November 7th, 2025, the archival case file had been reactivated. The pattern had always been there. The access logs that identified it had been retained, technically, in cold archival storage. What hadn't existed in 2015 was the analytical framework and the retrieval infrastructure to cross-reference access timestamps against leak event timelines at the granularity required to surface it. The 2015 investigation worked with the tools available in 2015. The 2025 review worked with something considerably more capable. The evidence was sitting in archival storage for 11 years, fully intact, waiting for a system capable of reading it correctly. The reactivated investigation moved quickly in its first weeks, and then it did not. The initial financial subpoena, targeting the defendant's personal accounts and those of his Texas-registered consulting firm, returned data within 10 days of the case reactivation. The domestic picture was relatively straightforward. Regular income from his consulting contracts, standard business expenses, nothing that would have triggered a suspicious activity report in isolation. The Cyprus LLC was a different problem. Subpoenaing a Cyprus-registered entity requires navigating a mutual legal assistance treaty process that, under normal circumstances, takes months. Cyprus maintains strong banking secrecy provisions. Its corporate registry does not disclose beneficial ownership information voluntarily. The FBI's legal attaché office in Rome, which handles MLAT requests for Cyprus, submitted the formal request on November 19, 2025. The response was not expected before February. The task force did not wait. The obstacle was timing. If the defendant became aware that his historical access records had been flagged, through any of several possible channels, including his own contacts within defense contracting circles, the flight risk was assessed as significant. He had a consulting presence in the UAE. He had demonstrated, by the nature of the original breach, a willingness to maintain relationships with foreign entities. He had a passport. He had means. The task force requested authorization to conduct parallel domestic financial investigation while the MLAT process proceeded through official channels. The authorization was granted on November 23rd. A financial forensics team spent the following 6 weeks reconstructing the domestic financial picture from the outside in. They identified 11 wire transfers received by the defendant's personal accounts between 2013 and 2016 that did not correspond to any documented consulting contract or domestic business relationship. The transfers ranged from $40,000 to $210,000. They originated from a correspondent banking pathway that, when traced forward, terminated at a Cypriot clearing institution. 11 transfers, $1.4 million total. No paper trail connecting them to any legitimate service relationship. By January 8, 2026, the forensics team had reconstructed enough of the financial architecture to support a probable cause finding. The MLAT response from Cyprus had not yet arrived. It would not need to. The task force applied for a federal arrest warrant on January 15, 2026. The application included the access log analysis, the financial reconstruction, and a classified annex summarizing the 2014 to 2016 NCIS investigation and its connection to the flagged access pattern. The warrant was signed on January 22, 2026. One problem remained. On January 27, 2026, a routine travel records review conducted as part of the ongoing surveillance identified a new international booking. Emirates Flight 235, departing Houston on February 14th. Destination: Dubai. One way. The task force did not know whether the booking reflected a routine business trip or a flight risk response. The defendant had made similar trips twice in the preceding 18 months, both round trips. This one was not. The task force escalated to the field office on January 28th. The arrest was moved from a planned residential execution, which had been the default protocol, to an airport interdiction. They had until 7:05 a.m. on February 14th. The operational planning for the airport arrest ran through 3 separate scenario variants before the task force settled on a protocol. The primary concern was not physical risk. The defendant had no weapons history, no known affiliations with organised criminal networks, no documented history of violence. The concern was evidentiary. If the arrest happened outside the security perimeter, before the subject had cleared customs and federal inspection zones, certain categories of evidence recovery, specifically the contents of electronic devices, would require additional warrant authorization that had not yet been obtained. Conducting the arrest inside the federal security perimeter, after the subject had passed through TSA screening, placed the event within a jurisdiction framework that gave the task force broader immediate authority over his carry-on materials. They would take him at the gate. The agents arrived at George Bush Intercontinental at 5:45 a.m. on February 14th. They staged in a coordinated pattern. 2 agents at the terminal entrance, 4 in the concourse, the primary arrest team of 6 positioned to approach from the gate seating area once the subject was confirmed, seated and stationary. The subject arrived at the terminal at 6:02 a.m. He checked in at 6:09 a.m. He cleared security at 6:14 a.m. An agent embedded in the TSA observation zone confirmed his clearance and relay transmitted his gate assignment to the arrest team, Gate E12. The lead agent gave the go signal at 6:22 a.m. There is a line in the arrest report that reads simply, "Subject was cooperative upon identification of credentials." That clinical phrasing doesn't capture what 6 minutes looks like when you are a man who has spent 11 years believing a file was closed. The agents identified themselves. They produced the warrant. The subject looked at the document for 4 seconds. He did not speak immediately. Then he put his coffee on the empty seat beside him, placed his hands on his knees, and said, "I want to call a lawyer." He was transported from the airport to the federal detention facility at 7:19 a.m. 14 minutes after the Emirates flight, he had booked departed gate E12 without him. The 2 mobile phones recovered from his carry-on bag were transferred to the FBI's digital forensics unit. The laptop was imaged on-site under the authority of the arrest warrant. The Cayman Islands bank routing slip, which had not been part of any prior financial disclosure or surveillance, was logged as a separate item of evidentiary interest. The Cyprus MLAT response arrived the following week. It confirmed the beneficial ownership of the registered LLC. It identified the nominee directors as professional registered agents with no operational involvement. And it identified the ultimate beneficial owner as a legal entity whose corporate structure traced through 3 jurisdictions before terminating, through a series of management agreements that Cypriot authorities declined to characterize further, in the direction of the Gulf region. The specific nature of that terminal relationship remains classified. Here's the take that will probably draw some disagreement. The original 2015 investigation was not a failure of intelligence. It was a failure of institutional will to acknowledge what the access pattern was already suggesting. The 34 files and 72-hour window were flagged internally, not by the investigation team, but by the server logging system, which generated an anomaly report that was reviewed, assessed as within contractual scope, and archived without follow-up. The contractor's SCI access had been granted as an administrative accommodation. Nobody had formally reviewed whether that accommodation remained justified 18 months into a mole hunt that was failing to identify its source. Nobody asked, who else has access that we have not fully accounted for? The system is not designed to ask that question about its own convenience decisions. That is not a flaw in any individual investigator. It is structural. And the cost of that structural gap, in this case, was 11 years and $1.4 million in classified intelligence transmitted to a foreign state. A federal grand jury returned an indictment on February 19, 2026. The charges: 1 count of conspiracy to commit espionage under 18 U.S.C. Section 794, 1 count of unauthorized transmission of national defense information, and 1 count of providing material support to a foreign intelligence service. The indictment does not specify the foreign state. That designation remains sealed. The defendant entered a plea of not guilty at his initial appearance on February 21st. His defense team filed a motion challenging the sufficiency of the probable cause affidavit on the grounds that the access log data was 11 years old and had been reviewed and effectively cleared at the time of the original investigation. The motion is pending. Do you think 11 years is too long for a counterintelligence case to remain viable? Is that a failure of the system to close what it opened? Or proof that the system, however slowly, eventually corrects itself? Drop your answer in the comments. We read every one. Bail was denied on flight risk grounds. The Cayman Islands routing slip recovered from the carry-on bag, which, upon examination, referenced an account containing approximately $340,000, was a significant factor in that determination. The defendant remains in federal custody as of the date of this account. The NCIS officer who originally supervised the 2014 mole hunt retired from service in 2019. He was not contacted during the reactivated investigation. His involvement in the original case is a matter of record. His awareness of the 2025 reactivation and the subsequent arrest is not documented in any publicly available filing. The 34 transit schedule files accessed in those 72-hour windows before each leak event covered routing data for 7 separate vessel classes. 3 of those vessel classes were involved in actual transit operations that NCIS had identified as potentially compromised during the original investigation. The other 4 were not. Whether the full scope of what was transmitted in those windows has been accounted for, whether Iranian military planners received information from all 34 files or only the subset that corresponded to the 3 confirmed leak events, is a question the indictment does not resolve. That gap is not administrative. It has operational significance. If additional transit schedule information was transmitted beyond what the 3 confirmed leak events account for, then there is a category of intelligence damage that remains unassessed. The FBI has not publicly addressed that question. The Cyprus LLC has not been dissolved. Its registered address in Nicosia remains active. No assets have been formally seized from the Cypriot account structure pending the outcome of the criminal proceeding. Whether the approximately $340,000 in the Cayman account will be subject to asset forfeiture is a matter currently under litigation. The defendant's Houston consulting firm remains registered with the state of Texas. Its active contracts, including those with UAE-based clients, have been suspended pending the resolution of the federal case. Whether those clients had any awareness of the defendant's prior activities or any connection to the financial architecture that routed payments through Cyprus is a line of inquiry that the indictment references in a sealed annex. That annex has not been made public. There is one additional element of the reactivated investigation that federal court filings touch on without fully resolving. During the 6 weeks of domestic financial forensics in December 2025 and January 2026, investigators identified a second set of wire transfers, smaller, later, originating from a different correspondent banking pathway, that do not correspond to the Cyprus LLC or to any of the 11 transfers already accounted for in the indictment. Those transfers total approximately $87,000, received between 2019 and 2022. They are referenced in the indictment in a footnote as a subject of ongoing investigation. Nobody has said who sent them. One detail that stayed with me: the Emirates flight that departed Gate E12 at 7:05 a.m. on February 14th arrived in Dubai 23 hours later. The defendant had been booked in seat 14C, a window seat on the right-hand side of the aircraft, positioned to see the approach over the Gulf as the plane descended toward Dubai International. Whether he planned to stay in Dubai or use it as a transit point to a jurisdiction without an extradition agreement with the United States is not something the court record specifies. The one-way ticket is the only documentation. What he had packed in that carry-on bag, what the digital forensics team found on those 2 mobile phones, has not been disclosed in public filings. The task force closed its operational file on the airport interdiction on February 15th, 2026. The criminal case remains active. The transit schedules for US Navy vessels operating near the Strait of Hormuz in the fall of 2014 are now 12 years old. The vessels those schedules described have since been reassigned, refitted, or decommissioned. The information has aged beyond its operational value. What has not aged is the question of how much of it was transmitted, by whom, for how long, and where the money trail beyond Cyprus ultimately leads. The file that NCIS administratively closed in January 2016 is now a federal espionage case with an active indictment and a defendant in custody. The $87,000 from the second wire transfer pathway has not been traced to a source. The Cayman account remains in dispute. And somewhere in the sealed annex of a federal indictment, the question of who the Cyprus LLC ultimately worked for is either answered or it isn't. The case is open. What was transferred may not be fully known. The warrant was served. The damage assessment is still running. If you want to follow how this case develops, and there will be more to report, subscribe. We'll cover the trial when it begins. And if you've heard anything about how these contractor clearance accommodations work from the inside, drop it in the comments. We read all of them.